Hey, I want to share with you the most important aspect of doing an injury intake in a medical malpractice case. So, for a lawyer, sometimes you get bogged down in all the details of looking at the records and evaluating all this. But I always say to our intake specialists, put the brakes on, because the first and only thing that really matters is, was there a severe or catastrophic injury? And so our criteria would be death, paralysis, loss of limb, blindness, and I forgot one of them, but it's in there. And so basically, that is the criteria that we use. And so with the intake specialist, before you let the new client start going into all the details about the case, stop them and break it down into 5 different criteria. Look at their current symptoms, number 1. How are you doing now? Oh, I'm doing fine now. I'm 100%. Great. Then we can't accept your case. So if they've recovered, it's not going to be financially worthwhile to pursue. How are you doing now? Number 2, medical treatment. Are you treating for your injuries now? Because if they're not treating for their injuries, with rare exception, it's not a catastrophic or substantial injury. So number 2, always ask them, are you treating? Do you have future plans for treatment? Do you have future plans for surgery? Number 3, objective test results. Have you had diagnostic tests that reveal the severity of your injury? That could be an X-ray, a CAT scan, a PET scan, MRI. So for example, if there's a nerve injury, you would ask, have you had an EMG, electromyography, that would give a objective measurement of the function of the nerve? So that's a really important question to ask in a nerve injury case. Number 4, physical limitations. Are you able to return to work? Really important, because if they're able to return to work, it's very unlikely that they have a catastrophic injury. Also ask them, are you limited in your ability to do things right now? For example, at home, basic activities of life. How has your marriage been affected? So find out what their limitations are both at work and at home. And 5, permanency. Has any doctor told you that your injuries are permanent? Generally, an assessment of the permanency of an injury can be made 1 year after the incident occurred. So if the person's neurological or nerve damage has not improved or recovered within 1 year, generally it's safe to say that that injury will be permanent. Now, if the nerve injury just happened 2 months ago, we've seen many cases where people have a complete recovery of nerve function in the first 12 months. So it's way too early to make a determination of the permanency of the injuries. Why are all these things so important? Because too many lawyers accept the case, file the lawsuit, and then realize this client's injury is not nearly as bad as I thought it was. And then they're stuck in litigation. They've got to see it all the way through. And that is an enormous waste of time and money. So before you do anything else, talk to your intake specialist. Have a dedicated intake specialist for your law firm and go over these 5 criteria to determine the severity of the injury, the symptoms, the medical treatment, test results, physical limitations, and permanency. Those 5 criteria, and that way you'll be able to limit what could be a 1-hour conversation with a new client and cut it down to 5 or 10 minutes. So that's it for today. If you like this video, please comment. I will respond to your comment. I love to hear from you. And also click that little bell next to the subscription notice, because if you do click that, you'll be notified every time I have a new video. And I post a new video every day in marketing and management tips for lawyers. And I look forward to seeing you tomorrow. Take care. Bye-bye.